Political analyst Professor Dirk Kotze is on the line with us via Zoom to talk to us about the process that's about to unfold. Professor Kotze, thank you so much for speaking to us. Perhaps let's just start with that last part that my colleague Bulelani Philip spoke about, the fact that Advocate Mkhwebane is still to appear before the Western Cape High Court to challenge this matter. Will that have any bearing on the process that is already underway?
Well, this is not the first court case that she has taken to court on this matter. And the previous one about her suspension was not adhered to. It was dismissed, and therefore it already set a precedent. I think it will be unlikely, based on that there's going to be a completely different sort of outcome to that. But obviously, that is still in the hands of the court in order to decide. But given the trend that we've seen over some time already, I think it is very unlikely that any court case will set aside the process as it is unfolding at the moment.
But is it not an injunction against the process?
No, well, I'm not sure about the legalities of this. I think the Parliament has enough legal advice in order to make sure that what they are doing is not necessarily against it. I think, because this is a matter which is based on the constitutional component of Section 194, I think the fact that they have adopted principles that were tested in the court, and the court ultimately accepted that it is constitutional, and that was one of the applications of Advocate Mkhwebane, makes it very difficult to see if there's any gap left in terms of what she can still challenge in terms of the approach and the procedure that's been followed.
Speaking of gaps, we see her legal team saying that there should be a parliamentary committee that establishes the grounds for her impeachment. But what is well underway now is an impeachment inquiry. That somewhat confuses me because it seems to suggest that the toothpaste is already out of the tube. So how do you then put together a committee to establish the grounds for impeachment if you're already having an impeachment inquiry?
Yes, I think there's very different opinions or interpretations of what should be done. I think the way in which it is formulated at the moment is that, and that is also what the Constitution is saying, is that a member of Parliament can table a motion about a section or Chapter 9 institution person, especially the Public Protector or the Auditor General, that it is then tabled in Parliament or tabled to the Speaker. She then, if there's sufficient grounds for it, refers it to a committee of 3 legal experts. Once they have submitted their report to Parliament, there's a vote by the National Assembly. Once that has been accepted, then it goes to this committee that we are seeing now. So we are actually in step 3 already in terms of the process. And that is set out by as I said, by the rules of the procedure that was tested by a court of law, and they accepted as a valid set of rules. Incidentally, it's exactly the same as the impeachment of the president, that also went to through a court procedure when President Zuma challenged it. So I think in that respect, there has been quite a lot of legal testing already of this, and to challenge it now, I'm not sure what is still left in order to be proven or to be tested in court, actually.
Okay, let's talk about continuous process and procedure. Advocate Dalimpofu, on behalf of the public protector, suspended public protector Advocate Mkhwebane, has accused those behind us of Stalingrad tactics, and he is also therefore calling for a secret ballot in terms of voting on whether or not she ought to be impeached. The political divisions on this matter, would you say they would warrant that a secret ballot? What would be the effect thereof?
Well, as the Constitution stands at the moment, it does not talk about what type of vote it should be, so that can still be decided. But it does say it must be a 2/3 majority in the National Assembly. So it means that it is not just a 50% or ordinary majority, like, for example, in the motion of no confidence, but it's a very special majority, which is very difficult to achieve under any circumstances, especially under current conditions where there's not one party that's absolutely dominant. And that was the whole purpose of the formulation of this, is the fact that it must be under special conditions, with a special majority, that this decision can be taken. If we look at other places in the world where impeachment processes are happening, it also goes through a similar process. It is also in Parliament, which is not a court of law. There is also the procedure that we are seeing unfolding now with someone who's leading the evidence, who's laying the charges and will lead the evidence. And then ultimately it's the members who are politicians in the end who are taking the final decision, because it is also they who went through the process of actually interviewing the candidates for the public protector and made the recommendation to the president. So they had a very strong hand in the appointment process of the public protector. And I think that is the justification why they can also be involved like this in the removal of the public protector.
Now, just looking at what is happening now, so Advocate Dalimpofu says there are a number of judgments which prove the public protector right, including the one that allowed him to address the committee. Yet the committee or the hearings themselves are taking place because there was consensus that there's a prima facie case against her. Just explain this to us, particularly the prima facie case, and we can talk about the 8 adverse judgments that the evidence leader points to us. But in layman's terms, when you are to explain to somebody who's listening to the political jockeying over whether or not this is right and whether or not it has a political agenda, what was the prima facie case that found that this is why there ought to be an impeachment hearing against the public protector?
Well, the evidence that has been accompanying the motion that was tabled in Parliament refers very much to court judgments. And when it comes to prima facie evidence, then it means not that there's already sufficient evidence to say, well, this, or evidence that says this person is indeed guilty of something. But it is evidence that says that that a situation that says there's enough evidence to have at least the inclination to think that there is a case possible against this person, that there is a case that must be answered by the accused, as well as being proven by those who are charging the person or putting it on the table for this committee. So it means that there is enough of a motivation, but the ultimate decision is still outstanding. And this is exactly what is now the main purpose of this committee, is to go through evidence, through testimony that is going to be presented from tomorrow onwards, as well as the defense of Advocate Mkhwebane, and then decide based on all the presentations that are made to them, plus the documentary evidence that's there, what ultimately will be their final decision. And I think what one should also keep in mind that this, because it's not a court of law, so it's not going to follow exactly the same procedure. And the members of the committee are not all legal persons. But in the end, it's not they who will take the final decision. They are going to make a recommendation, and then all 400 members of Parliament must be either convinced or not about the case that's presented to them.
And let's look at what the evidence leaders are arguing in terms of the adverse judgments, which they say point to, most importantly, misconduct and incompetence. But what I think has been very damning for a lot of people and has really raised the ire of those who are critical of the process is accusing her of not understanding her constitutional duties to be impartial, to fulfill her functions without fear, favor, or prejudice. But most importantly, they're saying confusing a misunderstanding of the applicable contractual, constitutional, and administrative law principles. Now, I want to bring all of this back to the argument. again, I say from the prism of those who are critical of this process, that the security cluster in this country, or institutions of government, have been co-opted, manipulated to take sides politically. Obviously, it's said that Chapter 9 institutions enjoy a little bit more autonomy from that subjugation. But is it possible that it is a matter of opinion, these allegations, in terms of her perceived misconduct, or what the evidence leader says is fact, based on the various court judgments against her?
Well, as I said at the beginning, as I understand it, and it's many pages of that's being added to the motion, a lot of it is coming from these court judgments. So what you have now quoted is to a large extent statements or conclusions by judges. And it's not members of this committee who have made these statements in the meantime. It's also not the person who's leading the evidence who's making these statements in terms of her own interpretation. It's based on, as I understand it, to a large extent, these elements coming from these different court judgments. And that is the basis of the accusations that's been made against her, is that it is the way in which the court made reached some conclusions about her, and the fact that so many of the court cases, in terms of whether it's reviews of her remedial action recommendations in her reports, or the conclusions that she reached in her reports, or some of the reports that went beyond her mandate also, that is the very basis of saying that or accusing her of being incompetent or incapacitated in order to do the work of the public protector. But I think the reason why it is presented like this is because it is key components of court judgments that's being used, and it's not. I would think it's not going to be about a person's personal judgments or opinions about what the quality of her work is. That will not be very convincing in a situation like this, when it is purely a sort of an assessment that's being made. I think what is more convincing is the fact that it comes from court judgments.
All right, thank you so much for your time and insights, Professor Dirk Kotze. He is a political analyst, right?